Probably most of you are surprised by what happened this morning. I don't want there to be any misunderstanding. We are not in any way conceding guilt. In fact, Jerry is more adamant than ever in his innocence and in expressing his innocence at trial. Today's decision was simply a tactical measure based upon an analysis of what was going to transpire. Most of you who have spoken with me over the course of the last 5 weeks realize that today's proceeding was only a preliminary hearing, a probable cause hearing. It was not a trial. We would not have been able to present any witnesses. We would not have been able to present a defense. In fact, we could not even have tested the credibility of the Commonwealth witnesses. All that would have happened today is that the Commonwealth would have had an opportunity to basically recite the allegations contained in the presentment that has been presented and filed against Jerry Sandusky in this matter, which really would have left us with the worst of all worlds. We would have heard a recitation of the allegations without realistically being able to cross-examine the witnesses who testified as to their credibility. And as all of you know, credibility is going to be the main factor in this case. Credibility is a situation that exists at trial. It's a measure which we can address at trial, but we could not have addressed today. And had we attempted to, I suspect we would have been foreclosed from doing so. One of the main reasons that we wanted to have a preliminary hearing and anticipated having one was because we wanted to be able to cross-examine Mike McQuarrie, who was involved in the allegations pertaining to accuser number 2. As most of you know, the credibility of Mike McQuarrie has been put into great question prior to today with various statements he allegedly has made, and we've verified the emails, but we still have not yet verified the comments allegedly made to Dr. Drainoff following whatever Mike McQuarrie said he saw in the shower room at Penn State University in March of 2002. Having done that and having realized that Mike McQuarrie's credibility was already a grave issue, we decided that when we looked at the strategy that we wish to apply in this case, that would make a lot more sense to waive this hearing and proceed with our defense, especially given the fact that we got a concession from the Commonwealth to address our pretrial discovery needs and requests in a reasonably fast way so that we can analyze that material more quickly and properly prepare for a trial. So again, having said that we anticipated nothing new coming out of this case by way of our defense and not being able to realistically present a defense or attack any witness's credibility today, we decided late last night that the better part of the tactical maneuver from our standpoint would be to waive today's proceeding, being very well prepared and realizing that we have much of the evidence we would have gained from today's proceeding without proceeding with it, putting everyone to the task of sitting in court for an entire day's worth of court hearings. Now, having said that, I'll be happy to answer any questions.
Mr. Amendola.
Now, wait, I want to control this. I can't answer 5 or 10 questions. I'll take you first.
Thank you. One of the attorneys representing one of the alleged victims went so far today to say that he thought it was an act of cowardice to go to this 11th hour to have those alleged victims face the prospect of having to testify in open court, only to pull that hearing away. Why make this decision at this moment when you could have made it days ago?
Because we did not have meaningful discussions. We did not have meaningful discussions with the prosecution until yesterday afternoon. And even after we did so, that it was not certain that today's proceeding would be waived. And in response to that particular comment, you know, I always have to chuckle at attorneys who make comments about other attorneys' cases when they really don't know all the details. And I try not to do that. So I'm not going to comment on his comment, but I will say this. It was the Commonwealth who insisted that all the witnesses be here today because they were concerned that Jerry might change his mind and might want a hearing. So it wasn't us. As a matter of fact, I told the Commonwealth attorney last night he could call off his witnesses. And he chose not to do so, and I understand that, because if Jerry had come into court today, even though we had agreed late last night to waive this hearing, then he would have been stuck with no witnesses. But that's the reason. We did not drag people into court. In fact, we tried to avoid that. And in fact, we tried to be sensitive to everyone. But unfortunately, because of the nature of the legal system, Until a defendant actually signs the paperwork and waives his legal process, no one can assume that's going to happen, not even I.